including our airfield.
Okay, good morning to all, board members, the public. I'd like to have a roll call, please.
Chairman Vincent,
Here.
Rex Sims. Here. Carolyn Gallagher,
Here.
Don Colapetro,
Here.
Henry Bird.
Here.
Jeff Naturo.
Here.
May I?
Yeah.
If I may, I have 3 ordinances on the docket before we get to the downtown right-of-way conceptual cross-sections. And we can probably do them pretty quick, but it's a little different than what you normally see. The first 2 relate to adopted master concept plans, and we can take them together. So what happened is community development were reviewing master concept plans, and there was a sentence that looked like it was a Scrivener's error, where there was a typo, and it probably was, related to extensions, and the question was, could that apply to reinstatements? And where it was structured, I don't think it would have necessarily, so we talked about removing the floating sentence, and this is the first ordinance. So this is ordinance A, and let me read the title block into the record for that one. This is an amendment to the Bonita Springs Land Development Code, Chapter 4 zoning, amending Section 4-303, duration of rights conferred by adopted master concept plans, clarifying the intent that Community Development Director may obtain additional information during applications for reinstatements and extensions of master concept plans, providing for conflicts of law, severability, codification, Scrivener's errors, inclusion in code, and an effective date. So this was an ordinance that was suggested by outside Special Land Use Council, Theriac in Spain. What the ordinance does is it deletes on page 3 the location of where there is a floating sentence, meaning the sentence doesn't have a number assigned to it, and it inserts it at the end of both sections for reinstatement and extensions. This would be allowing staff or in community development to get whatever additional information is necessary for processing the request. This was the first ordinance that was drafted on this. The second ordinance, and I'm going to read that title block at this time because these ordinances should be done together, is an amendment to the Bonita Springs Land Development Code, Chapter 4 zoning, amending Section 4-303, duration of rights conferred by adopted master concept plan, prohibiting applications of reinstatement of expired master concept plans, providing for conflicts of law, severability, codification, Scrivener's errors, inclusion in code, and an effective date. Now, what this ordinance does, and this is the second ordinance in the packet, what it does is actually deletes the ability for a reinstatement after August 1, 2017. So many communities, and this was also at the recommendation of Special Land Use Council, Theriac in Spain, many communities do not allow reinstatement. They require people to go back to square one if the master concept plan has expired. Now remember, some do expire once you reach a certain level of vesting anyway. But if you received the zoning, let's say you received it in 1995 and you got your extensions, but then you finally didn't get an extension, the government could require you then to go through the process again. This would require you to go through the process. What this did was basically Nazarene in the effect that it actually resurrects old master concept plans, and some of them may be compatible, some of them may not be compatible. Now, the reason I'm asking you to review the ordinances at the same time is because council will not, obviously council will not adopt both of them. Council will adopt one. But to provide council with the greatest flexibility, both are being advertised at the same time along with the ordinances you reviewed last month, the supermajority and the design standards. So they can pick from, I want to say pick from column A, can pick from column B, but they can choose which one they want at the second hearing.
Okay. Is there any
I have a
questions?
question, just for clarification. If the application is done in phases and the second one expires, it doesn't have any influence on the first one?
No, again, if something is vested, but I think, I have to look at John Dolner or Jackie, I'm pretty sure that once an ordinance has gone through, or once a development has started, You pretty
Well,
much treat it
actually,
as.
what I think you're asking about is whether a zoning is approved as phases. We don't have too many zonings approved in phases. We have a lot of development orders that are phased. So what you're asking for at a zoning level is
a
very rare.
development order process rather than a zoning process.
Correct,
Okay,
yes, sir.
I got you, John. Thank you.
But once a property is vested, it's vested, but
Yeah.
then we pretty much know what is going to happen with that property.
So I'm looking at allowing the community development director to get additional information. And that would be, I guess, because when you having a reinstatement, there may be a lot of time that lapses between the two. Therefore, new information might arise,
That's,
and you have a reason for those questions.
that's correct. I mean, transportation, TISs, environmental,
Right.
species may want to come over to that property.
You also have new council members with different focus and different priorities as well, and that's really where
Yeah,
you
I
see a
thought
change
that,
in focus.
and that's, to me, that's appropriate to be able to ask more
And
questions.
the comp plan changes also. I mean, the
Yes.
comprehensive plan, the vision, LPA changes things or recommends changes throughout the years. And you have things that, property that had certain rights, a bundle of rights, but it was never acted upon, and they did not continue extending. And nowadays with, all right, so I don't know how familiar you guys are with this one, but the state of Florida during the Great Recession adopted two legislative that mandated that we give all development a certain amount of time. I want to say it was like 3 or 4 years, maybe 5 years. Then they adopted legislation. It's in the Stafford Act or the Emergency Management Act that requires, if it at an applicant's request, they have to affirmatively ask for it. If the governor signs a declaration of emergency and you're in an affected county, and some are statewide, some are just local, or just announced by county, and others are statewide, you are mandated by state law to give an extension to any permit as defined in state law, which could be a rezoning, it could be anything, or not anything, but it's close to anything, for 6 months plus the time period of the emergency. So some of the emergencies, Lake Okeechobee, there's 4 emergency orders. I'm looking at Jackie to see if she knows the exact amount of time. We don't at this point. But some of the emergencies, when it takes a long period of time, can go through. In 2017, the governor has signed 2 new declarations of emergency, one on statewide, one on fires, which is, I think fires, and the other on the opioids epidemic.
So it
And
might,
Zika is another one.
right. So it might, you might say that number 2 gives rise to number 1. In other words, that can't be a standalone without number 1 being in effect as well.
Right.
That's why these two are being presented at the same time.
So if you're, right, so, right, at the end of the day, council has to choose one or the other. And they can either allow reinstatements, which is kind of archaic. Most governments do not allow it. And the problem about allowing reinstatements is it does not provide a definitive idea of what your community is going to be. It puts everything into a helter-skelter as opposed to having a final development. So it's one of the vestiges that from Lee County that we never looked at, and it's in the code.
Okay. Any comments?
I had something that's a little off the subject, but you did mention it. I was curious on page 4 of 6 of the first one. You'd mentioned endangered species, and that was one of my notes. So I am curious why we have this in here about the traffic impact statement, which would be number 4 in the middle of the page, but nothing about endangered species.
This is not the code changes. This is
No.
the current language.
I
But
know.
I think at one point, we had a city council that was probably more auto-centric, concerns of vehicles.
Traffic tends to change faster than species locations. However, one of the reasons why there is a statement or a request to put in additional information as may be requested or required to review is because there could be changes in the environmental condition.
Could
So
you
this would be
put
one of the things
an-
that could be covered in there.
Like a, for example, e.g., endangered species?
I don't know if that would
and-
necessarily be helpful.
I know it's
because I
required in
think
the comp
it's-
plan, but
Well,
Correct.
having
If there's a change in status, there's a change in submittal requirements.
I just wonder, I see traffic and I didn't see the other one. They're both required in the comp plan.
There, for a reinstatement, if nothing has changed in the environmental condition, then there's not a requirement to update that. However, it
But
will,
how do you know if nothing has changed unless you have a report?
because we send somebody out there from our staff, and generally the applicant will also send their biologist to the site to make sure that the existing conditions are still the remaining conditions. And if anything has changed, then they'll update that study.
Okay.
So you have two people on the ground that confirm.
Yes.
Any further questions or issues or comments?
One other
Yeah, go ahead.
further one, and it's number 4. I think, excuse me, it talks about a request for an extension or reinstatement may not include new uses or increase the density or intensity of the development. I'm just curious, the density or intensity, would that include the height here? And
No, ma'am. The intensity and density would simply include the square footage of property requested or the number of units requested.
okay, and the reason I ask that question is the city council has been so concerned about things affecting density and height.
If they were looking for an increase in any development standard that would create an off-site impact, that would require a hearing. Anything that would not create an off-site impact, generally there's a standard that allows for administrative reviews and also a standard that allows for public hearing reviews. You know, if you're looking for are you looking under the section that states for reinstatement?
Yeah.
Page
Pages
4 of
are the,
6, on the duration, subsection 4.
A reinstatement is
see.
simply
Yeah,
that. A
reinstatement.
reinstatement is asking to renew what was previously there. If you would like to change development standards, that's not a reinstatement.
Okay. So we're making the assumption then that's already been approved, the height and everything, so
Correct.
it would
but they
come over
would.
the same.
A
Okay.
reinstatement is simply that. It is taking what was approved but has expired.
Yeah.
And-
I mean, it just, when you say one thing,
Okay.
but there's something else that kind of goes along with it, but you don't say the second thing, you know, like you say
Well, I
traffic,
think that
but you
you're
don't
just trying to
say
make sure that there's a
endangered
line.
species.
There's a line drawn between what is a reinstatement and what is an amendment.
Okay, I'm just curious. I'm sorry. This all helps me, so.
And so, in other words, the reinstatement is an exact reinstatement. Okay, do we have any comments from the public on this issue?
Not very
And since
exciting.
there, right, is none, can I get a motion?
I'd make a motion that A and B together are consistent with the Bonita Springs Comprehensive Plan.
Second.
Okay, we have a first and second. A vote, please.
Chairman Vincent,
Aye.
Rex Sims,
Aye.
Carolyn Gallagher,
Aye.
Don Colapetro,
Aye.
Henry Byrd,
Aye.
Jeff Matero.
Motion passes. Let's go on to the next item, please.
Thank you. The next ordinance is again a request by Special Land Use Council, Theriac and Spain. I'll read the title block into the record. This is an ordinance of the City of Bonita Springs, Florida, declaring a temporary moratorium related to the Bonita Beach Road Visioning Study and Quadrant Study in the Comprehensive Plan Amendment approved May 3rd, 2017, as ordinance number 17-06, establishing a moratorium on the processing of any zoning or other community development applications within the Bonita Beach Road quadrant map or Bonita Beach Road corridor area, the network zone map, providing for severability and an effective date. This ordinance is, again, as I mentioned, recommended by Theriac and Spain, which is the city's Special Land Use Council. Before the city adopted, the mayor had received letters, as well as things were added to the file related that there may be a potential challenge to the comprehensive plan amendment based on what has been submitted to DEO. The challenge takes 31 days, or it has to be done within the first 31 days of when we adopted. The ordinance was adopted May 3rd. In order to meet my LPA deadlines, I had to hurry up and bring this ordinance forward. So there will be some changes to the ordinance that you have in front of you. And I'll talk a little bit about that in a second. But the city's position is this is a temporary stopgap. The moratorium is very temporary in nature. In fact, it might either not be adopted whatsoever if there is no challenge within that time period. The term of the moratorium is, let me go into here, is only until such time, is for 1 year or until such time, look for the section, or until such time that the ordinance in 1706 goes into effect. The geographical application is also limited to what we refer to as the Bonita Beach Road corridor. There's two maps marked Exhibit A attached to the ordinance that have Exhibit A1 and Exhibit A2, which has a quadrant, and then the network zone map, which is from Tool and Design, or originally was prepared by Tool and Design. And it's to give the ability for the planners to actually implement the moratorium, or implement the Bonita Beach Road quadrant map or the vision study, which was found consistent by this local planning agency and adopted by City Council and has gone through the process with the State Land Planning Agency, which is, of course, Department of Economic Opportunity. So we have a very limited time frame for the ordinance because it will automatically dissolve, no further action by council upon the effective date of the ordinance. And it does affect permits that only would have an effect to the Bonita Beach Road Vision Study. So if, let's say somebody's doing interior remodeling.
I have a question.
Yeah,
The vision study encompasses the entire 11 miles.
correct.
Okay.
That's Exhibit A2.
Well, in our map here, we have a couple of intersections that are highlighted, and I wasn't exactly sure how that spun in this.
So that's map A1.
Yes.
So A1 is the quadrant plan.
I understand that.
And we don't have it map specific, like we don't have alignments drawn out, and that's because there's two cases. One is called joint ventures, the other one is
Well, I
called
just
Right
wanted to
versus
make
Palm
sure that
Beach.
the entire 11 miles was, that is the area we're talking.
And that's the reason why map A2, which is will be in the comp plan, is in there. I took these straight from the comp plan.
And the processing for anything would be for that whole number of miles,
That's
right?
correct, from the Teal
Yeah.
to the terminus, I want to say Docks Beach House area.
And what was I reading that particularly focused in on the southern side of the road? Or-
That's where the sidewalk's going to go. That's where the bike path's going to go.
For sure?
I'm going to
Chairman.
defer to Rex on that or
Okay.
to staff.
There's a multimodal path that's on the south side. So if you're looking for something that's specifically focused on that side of the road,
Okay,
that's
so
probably
for,
what it was.
you're for sure it's going to go on the south side?
Well,
Yes,
that's
ma'am.
what we sat here and did.
Yeah,
Okay.
there are no construction drawings, but the vision statement shows it on the south side.
Okay, all right.
Now,
I
the
just-
draft you have is dated May 4th. There have been adjustments, and also Theriac and Spain have additional adjustments to the ordinance that I'll be receiving next week. But the purpose of the ordinance, the moratorium stays the same, so I would contend it still falls within your review, even though there will be changes, and that's not uncommon for us to have changes after. Section 3 and Section 4 are probably what I consider the meat of the ordinance, and I do want to make sure, especially for the public out there, there are some assurances, because this draft, I did make some changes to this draft to do it. So how does a person, it's a very large area, Bonita Beach Road. So we don't want staff to have a complete moratorium on anything that could go out there. So it's only if it's something that's the moratorium isn't, they can continue processing things, they continue having pre-applications on anything that does not affect the Bonita Beach Road vision whatsoever. That's easy. they can continue, building permits. That's not going to be an issue. The next one is there are going to be people who are going to assert legal claims, and that could be at any time during the moratorium if the moratorium gets enacted. So we have a relief valve, very short processing period, so we can take it to city council immediately, and they could say, yes, we think this claim is valid, or, we think give them, or they can say no. They can also, if the applicant is voluntarily complying with the provisions in the potential comp plan, the goals, objectives, and policies that were contained in ordinance number 1706, then they can also be continued to be processed. But it does also affect development orders and anything else. So if somebody's putting something where we know will destroy a connection, or for the multimodal path, or will create a issue with potential alignments, even though it doesn't guarantee, they can work on changing the alignment, and negotiating and discussing with staff, but they cannot, hell no, we're not doing this, and you're out of it. So like I said, it may not even go into effect. It only goes into effect if we actually get a challenge materializes or emanates from this adoption, and we'll find out from there. I would contend it is consistent with the comprehensive plan, because all it's trying to do is make sure that we enforce a provision of the comprehensive plan, which the LPA recommended to go to city council.
Questions or comments?
Yes,
Don?
Mr. Chairman. Exhibit A2. I find it a little disheartening that on an 8.5 by 11 sheet, we have about 1 square inch of an area that's in question. It's a little poor in my estimation, but I want to draw your attention to the pink zone, which is supposed to be the historic zone. That appears to encompass Industrial Street. I'd like someone to explain to me how that highly commercial or industrial area got into the historic zone.
There is a portion of that that is included on this map, and that portion of it is either directly adjacent to Bonita Beach Road or still within direct line of sight of Bonita Beach Road. Once you start getting north on Industrial Street, that property is not included in here. I think you're talking about properties further north, especially when you get into the old packing houses. Those are not
Before
included
that.
in this map. I think that if I remember correctly, on a larger scale, this included 2 properties, maybe 3 properties, working north from Bonita Beach Road.
And
It's like
those-
LB, not LB.
Well, that was the area
other-
that we
the
had
same
a
place.
discrepancy on the map. Do
Exactly.
you recall, they were not included in
The western side of Industrial Street
yeah,
is
the
not
western
included in
side of
041.
Industrial Street didn't appear on the map.
Yes, sir.
So the zoning did not change in those.
Correct.
So whatever was there before is there now.
Correct.
And if I may elaborate,
Whatever is there before is there now.
It's basically the standard zoning that has been in place since zoning was
Okay.
created in the city.
All right, that's good to know.
and for clarification, this is Jacqueline Genson for the record. Mr. Calipetro, this map is straight from, or very similar to, the map that was prepared by Tool Design Group as part of the Bonita Beach Road Visioning Study. And what he proposed was that this area be defined as the historic zone, and really to demonstrate certain characteristics of site design, block design that he would envision and recommend for this area. So this map comes from the visioning study itself. So just to
Okay.
give you some
And
background.
the map actually, it's genesis of the actual boundaries, at least not so much in the teal section, which is relatively new, but is the Bonita Beach Road Corridor Ordinance from 2001 and 2002 that the local planning agency created.
So let's try to be a little specific here. What's the footage from Bonita Beach Road on Industrial Street going north
What,
that you consider an inclusion zone?
what exactly is the concern of property being included in this?
There are 2 properties in particular.
Mm-hmm.
That would be B&L and the welding shop.
And where are your concerns lying in terms of their inclusion or not inclusion within this map?
That they have, that if those properties, if those owners were to sell those properties, does the current zoning stay with the property?
The current zoning stays with the property. What we're looking at with the vision is basically an aesthetic and a development guideline. It's not changing uses. We are simply looking at how these properties relate to the roadway itself. The reason why our consultant chose the properties he did to be included in this map were that those properties had a direct impact on what he thought could impact his vision of that corridor. You can agree or disagree. That was simply why it was created. That was why it was presented. The City Council ultimately agreed, and that is how the map was created. In this particular map that we're looking at, it's taking that vision map and saying that those properties that are included in that map, we want to make sure are included in this moratorium. It's just like for like. There was not a change in that map to this map.
And I want to point out something, because I talk about it with the zoning board. I don't think I've ever mentioned it to the LPA, and I also talk to council. Zoning runs with the land. It doesn't ever run with the applicant. So if Burnwood sold, it would not, that would not be a change just because there's a change of the owner. There has to be an actual change in application coming before us, a change of use, that you would then have it. Now, in this particular case, I think they're grandfathered anyway under their conventional zoning to what they have, and the uses and whatever IL allows now, or IL light, it's industrial light, yeah, IL, I think out there. So, but it does run with the owner, because one of the things I always tell council as well as the zoning board is never, ever, ever give a zoning because you like an applicant, because that applicant could go away next week.
Rex?
John, on this moratorium thing, it's going to be for a year maximum, or somewhat less. If a developer was working on a project out there, would that have an effect on his financial package
I don't
in
know.
any way?
And I'm going to say I don't know, because it could, but it might not. Financial arrangements are not necessarily controlled. They're definitely not controlled by community development.
I think we're doing this kind of, and it could have some very serious effects.
Well,
And we
and
want to make sure that we're making this good for the citizens
Well,
as we can.
and I think that's why you see the number of exceptions that are in there, because
Okay.
the purpose of this, and I don't want to try to include all the purposes, but one of the purposes was to make sure that since the city has gone through the effort and the exercise of establishing a vision for this corridor, allowing properties to develop inconsistent or in a way that degrades that vision doesn't help create that vision. So if an applicant wants to work in that vein, this moratorium, the exceptions included, allow us to do that.
Okay.
right, the purpose of a moratorium is very similar to a zoning in progress. Our objective is to make sure that we're not having people run to the front desk counter at community development to turn in an application, say, aha, I beat you to before you were able to do something. We want consistency with the comp plan, and actually applicants should also want consistency so that they're able to have a continuation and not be grandfathered into something that then makes the property more restrained in further processing of those applications, if they need a change.
Let me ask, map A2, Exhibit A2, this is graphical only, it's graphical purposes. When will it be defined as to what the outer extent of these areas would be? I mean, when you're looking at developing something, you want to know how much you're inside a zone or out, and whether or not, this is a dream or is it existing now. How do I apply?
We have this broken down on a parcel basis. However, when you're putting together packets for public hearings and for distribution, I understand the concern of having an 8.5 by 11, but printing 50 copies per hearing of 24 by 36 just is not realistic. So I understand and appreciate the concern. However, addressing that concern becomes a little difficult when you look at cost of printing maps of that size. We do have this broken down on a much more detailed basis, and if anyone is concerned, we would obviously be able to answer that question. Also, I think that we could probably do something in the way of a map on the website, maybe that shows a little more detail or at a little better scale.
So the way you look at this is that this is what we would like it to be, and these are the things we'd like to have in these areas, these zones. So a developer would say, I see where you're going with your thoughts. It's not been approved by the council yet, but this is the direction the city would like to take.
The
Well, it has
vision
been
has
approved
been.
by council.
It has been.
The vision has been, but I think what the question that's come into play and the reason why this ordinance is before you is because if that adopted vision is challenged, that adopted ordinance cannot be enacted officially. However, if somebody wishes to voluntarily comply with that or the intent of that ordinance, their application should not be halted.
But in the grand scheme of things, the council is saying, we like the direction that these zones are taking.
Yes, sir.
I mean, that's what this map says, is that
Yes,
we
sir.
would like to go in this direction. And so you're saying the moratorium is just to halt any sort of development until you get this, the arguments against it or improvements to it taking place.
And
Right, the clock is ticking, so
Right.
as soon as that time clock has expired, we just didn't want somebody trying to beat the shot clock.
Right.
So we have the, and that was why outside counsel said, you got to put a moratorium, and so we started the moratorium process, which obviously you can see people have been noticed, people are aware of it, and they'll discuss those issues because I understand, I'm empathetic to them also. I mean, I can understand, but I mean, it is the city's council's vision. It has been adopted by council. It will go in effect very soon. The problem is that, you know, we don't know if there's going to be a challenge, but we do know people have placed objections on the record to formulate a challenge if they so desire. I can't tell somebody you don't have a right to challenge us, but at the same time, I think the city has a right to make sure we put a moratorium so that the city's vision, as the LPA recommended, still goes forward.
Well, Rex, to follow up on your question here about cost to developers for this, what are some examples of the impact that it might have, I guess, on the impact of these zones? What sort of financial problems would it cause for someone developing?
I'm not sure that I would see an impact based upon the zones themselves. What I think I've heard is a concern of how the vision will be enacted, and that's going to be more of a site design or an aesthetic concern. So if someone wants to develop in a way that is inconsistent with that vision and is dead set on that type of design, and generally speaking it'll be a suburban type of design with a large parking lot in front and the building in the back of the property, that is inconsistent with what the city has asked for along this corridor, regardless of the zone. So there are certain changes that take place between each of the colors, but that's generally the pattern. And if someone is dead set upon that development pattern, going against that development pattern, what I think the city attorney is saying is the city should be able to hold that application until we determine whether the challenge is valid or it's invalid. If the challenge is invalid and the ordinance and the vision is enacted, then we can require those standards to go in place.
But for the time being, or even after this is enacted or approved, the current zoning use would go with the property as it is.
Correct.
Correct.
And there
Now-
is no amendment to the zoning
Right.
associated with this.
So those people, for example, that are in the historic zone, it would not matter if they sold their property to someone who wanted to continue the same use. It does
Correct.
not impact them.
That is correct, and that also applies to uses that are legal but non-conforming. Legal non-conforming uses anywhere in the city are allowed to transfer ownership. However, if they cease to exist for 6 months, they lose their legal status. So if a use that was legally permitted, but the regulations have changed where it is no longer conforming with the current standards, if it ceases to operate for 6 months, you cannot reopen that business or reopen that use.
Okay.
But that's no different than anywhere else in the city.
So that's the reconciliation that the designer of this plan has or has come to is that after 6 months, my dream will be fulfilled, if you will, with the new zoning.
Yes, I think you could say that, but I think that that was really carrying through the city council's vision that as they
Right.
continue to adopt regulations, as uses ceased, their replacements would be consistent with current regulations.
That's
regardless
what
of
I'm
whether that
looking
was
at, is
structured.
that, the city has a right to have a dream about what they want to be. Therefore, there has to be something in place that allows that to happen over time.
Yes,
Right,
sir.
and let's remind you guys, this has been a dream that has been worked on since 2014. So this is not some willy-nilly, let's do something different. This has been something that the city has been actively working on to get it processed for several years.
Right, that's the point I wanted to, I'm glad you said that, because, the city does have the right to look ahead and to dream a bit about what it could be. So, anyway, any other comments or questions?
It would be a disaster if we couldn't, I think,
Exactly.
because we could have a sprawling mess.
So that's the
Maybe
whole
not that
purpose of a
bad, but-
comprehensive plan.
Right,
I mean, that's the
exactly.
reason for Growth Management Act in the first place.
Could I just go through one time so that I understand the timing and the process? Now, starting out, for any applications that would not be going with the quadrant plan, this would apply to. So anybody who's going along with our plan can continue to put in their applications and do it. Now, you talked about the 30 days. Does that go, if this is approved, does that 30 days let them go up till the 21st of July?
As
To-
far
to-
as applications? Or what are you-
As far as an application or what is my, trying to fight it?
As far as their vision versus what
Oh,
the
a
city.
Right,
a
right.
challenge.
No, if-
So that their challenge would stop at July 21st? Their ability
no,
to bring a
the
challenge?
would stop 31 days from May 3rd. Is it May 3rd?
Oh, from when the city council approved this? Okay,
We might have, right, which we're hoping now there may be.
June 3rd?
Have you sent it to DEO already? It was sent yesterday. So there is a possibility, I need her to check the statute, if they have 31 days from the date it was sent or from the date of adoption.
Oh, okay, so, all right, so
And it
we're,
runs coterminous with the city's
for
effective
most,
date anyway.
so since the city council already approved this, this is already in effect?
Not
Start.
the moratorium, but the,
Well, not the not the year, not the date of the moratorium, not the
Correct. Well, what
21st
you-
of the
The
21st.
standards of the Bonita Beach Road vision have been adopted. However, with all ordinances, there's a 30-day period before they become effective. So we are in that period where it has been adopted but is not yet effective.
that's our charter. Now, state law,
And it becomes effective 3 June.
hold on, no.
Okay.
Okay, so let
This
me
is where I'm
back up
getting
a little
confused.
bit. So, council approved the ordinance on May 3rd,
Mm-hmm.
okay? We have to get it signed. It has to actually, normally the ordinances go into effect when the day the city clerk dates it, when she receives it back from all the routing and signatures.
Ah,
Then, after, hold on, it gets better. After all that, under comp plan laws, the city clerk says, hey, community development, the ordinance is ready for you to send to DEO. They come over, they retrieve it, they verify they have everything in the packet that is necessary. They then overnight it, they send it by overnight mail to DEO, which is the State Land Planning Agency. DEO stamp receives it. It was sent yesterday, so they should be receiving it today. And so the 30-day clock, or 31-day clock for challenges runs from probably this afternoon. So I would say June 12th would be the final day somebody could, like, it might be June 11th, so don't rely on me applicants or objectors, but that would be the final day that somebody could turn in something.
Okay, why don't we get
okay,
public?
okay, that makes
Okay.
more sense. Okay, so they have then that time to do what they need to do. And then, then you're saying that if nobody comes forward, then this will just not be effective. Is that?
Right, we'll pull it from the second reading. So
Alright.
at that time, we don't need a moratorium if the ordinance is in
Right,
effect.
right,
Because
right.
the ordinance would dissolve anyway the day it goes in effect, so why would you adopt something
Okay.
only to have it
Okay.
dissolved?
Now, I mean, I personally think this is a good idea. I don't have that. I just wanted to understand the
It's-
timing on it.
It's certainly more aggressive than I've done other moratoriums at the request of council. I don't typically, I think moratoriums are very serious, because it is very upsetting to your economic community. It's upsetting to the property owners. It's upset applicants. You want to have a certain level of stability to start, and you want your projects to be timed. And all of a sudden, we're putting a potential kibosh on timing of projects, and time is money. People borrow money for their projects. So I get that. I understand it. I am sympathetic, but the vision is something that council feels very, as well as this local planning agency, felt very strong about. So that's where we're coming from.
Well, the
but-
vision is really important for the future.
Right.
And the vision will attract a lot of other people to the city,
That's the-
without a doubt.
Right, and there's people who are believers, there's people who are not believers. There's planning, just like law, architecture.
But that's the
Everybody has
intent.
different viewpoints, right. And we get that, we understand, but that's for council to decide what is consistent and what's not consistent with its comp plan, with its vision, with the Growth Management Act.
John, thank you.
Yes, sir.
I'd like to call for public comment now. Please state your name. And I think you have some sheets that you would hand over to.
I've got a PowerPoint presentation.
Okay.
Good morning, Sam.
Morning.
Can we call that up? A couple of quick comments to address some of the concerns I heard.
Who is he?
I'm Mike Maurer
Yeah.
with Engel & Volkers Commercial Real Estate. I represent the Burnwood property at Bonita Grand in front of Hunter's Ridge, where the Publix is. I think that the city should have a dream. We talked about the vision, and I think that's a good thing. And I believe after this presentation, you'll see that our dreams, me and Mr. John McGarvey, are aligned with what you guys are trying to do. It's just that due to timing and due to a significant piece of property being under contract at this time, in the event that this moratorium does get enacted, which we don't know if it is going to be challenged or not, but we have a feeling that it might be, and that's why Audrey brought this to our attention, is if it is challenged and this moratorium goes into effect, we're going to get caught up into this, and it will result in a financial burden. So let me get started with the presentation. How do I turn this on? Oh, here we go. So the Burnwood Park of Commerce is located at the southeast quadrant of I-75 and Bonita Beach Road. It was zoned in 1995. It's a mixed-use planned development. It comprises roughly 80 acres. Roughly 50 to 60% of the park is currently built out, and about 90% of the infrastructure is in place. We've recently sold, which you'll see coming out of the ground right here, 4.5 acres to CubeSmart, which went through City Council extensive scrutiny and architectural review, which Sam was part of. That building's coming out of the ground now. The back 17 acres here and 6 acres here adjacent to Publix, that is currently under contract to McGarvey Development. That will be a mix of Class A office and industrial flex space. That contract is scheduled to close at the end of the third quarter of this year, so the end of this summer. So Mr. McGarvey is in extensive due diligence at this time, and we are moving forward with preparing all the civil engineering and associated legal work that needs to get done to process the development order. The vision study, as we all know, was really initiated because we had a traffic issue and we had a walkability, pedestrian access, bikeability issue, specifically during season. And the focus of the majority of the complaints was because of the beach traffic at Sunset. During season, at certain peak hours, there was traffic being stacked at US 41 and Bonita Beach Road, as well as down by Doc's Beach House and the intersection by the dog track at Old 41. These are the quadrant areas that are referenced in the exhibit, and these were really the focus areas and the crux of this vision plan. It's how do we fix this, because they didn't want to have these giant highways in the middle of town. We're in agreement with the plan. We're residents, we're landowners, we're business owners in the community, and I think it's a very valid dream to have, and it needs to be addressed. However, we believe that the ordinance needs to stay focused on these quadrant areas and needs to be less aggressive for the 8.5 or 11-mile stretch of Beach Road. We understand that there needs to be pedestrian access and walkability. However, in certain areas, it doesn't make sense to have cars parking on the side of the road, i.e. at the interchange. And there's certain areas that need to be less scrutinized with respect to current developments coming out of the ground, so long as they meet design review, so long as they meet the intent of the vision. These projects need to be green-lighted and allowed to proceed. During the public input sessions, where we had the giant tables laid out here with the maps, and they had the tool design group with the aerials and their proposed improvements, I attended those on behalf of the Burnwood landowner. And my table was in the back corner over there, and it was for the properties east of 75. And there really wasn't any description of any work to be done. It was just basically a sidewalk on the southern end of the road with a bike path. I contacted a couple of consultants at that meeting. They didn't really see any issue with what they were proposing on that side of the road. It was kind of like, Mike, we're really focused on US 41, alleviating traffic by providing alternative roads and ways for cars to scoot around that intersection, and to also solve the traffic and parking issue down by the beach. So when I attended those meetings, what I'm trying to tell you is that the focus really wasn't on us. It was really on certain parts of Bonita Beach Road that have issues. When you read this moratorium, and moratorium is a word that people get scared about. I certainly did when I first read it. It seems to me that there's 5 or 4, depending on who you talk to, who you agree with, points or boxes that need to get checked for any developments that, or if this moratorium goes into effect, would get processed, that would say that you're quote unquote in line with the vision. Okay? The first would be, and probably most importantly, is creating walking and biking infrastructure to allow pedestrians and bikers to go to stores or go to church or go to wherever they're going from their home to and from without having to get in their car and not feel like they're in danger. Okay, I think that's probably the most important box that needs to get checked. The second is to incorporate mass transit along Bonita Beach Road, i.e. bus stops or trolley stops, additional parking, taxi stands. The third is reducing traffic on Bonita Beach Road. So if what you're doing is reducing traffic by creating alternative means for drivers to get to and from businesses and back to their houses. Fourth would be connectivity between neighboring developments, making sure that the projects that are next to each other, there's a consistent flow, a consistent traffic pattern, there's reverse frontage roads, the sidewalks align, so that there's continuity along the road so that it looks like it's one master planned road. And the fifth, which I know certainly members of staff and John will touch on this later, is the architectural and design. I'm not a big believer in pushing buildings up against the road, and I'll let John, who's done a couple of those developments, expound on the negatives of what happens with those types of architecture. But I'm not here to weigh in. But I think if you check 4 or 3 of these boxes, you should be able to be exempt from this moratorium if there's a current contract on the table within a master plan park that ensures the protection that what comes out of the ground is going to look like and feel like what the vision is all about. The Burnwood Park of Commerce has MPD zoning in place and is current. There's a master development order in place for all the infrastructure, water, sewer, roads. Acceleration and decel lanes were in place, full median cuts were in place, Bonita Beach Road was widened. This was all done at the expense, not of the city, but of the landowner. We have at the Burnwood Park of Commerce very stringent development criteria that's recorded in our covenants and deed restrictions. We don't allow metal buildings or metal fencing. All driveway aprons into each individual building have brick pavers. There's a like monument signage. There's a like pylon signage. No visible AC units. They have to be shielded. Cypress or indigenous plantings are in all of our dry retention areas. We have extensive perimeter berm landscaping. We require each lot owner to put in additional landscaping. There's architectural review. There's ingress and egress review, where their driveways line up to make sure that there's safety and that the cars are not put in a place where they're going to get hit. We have interior street and parking lights. There's dumpster enclosures, and we have setbacks that are recorded from both Bonita Beach Road, Hunters Ridge Boulevard, Bonita Grand, the lake, and individual buildings. The high-cost perimeter berm and landscaping that's there now with mature trees was put in place, and I think is probably one of the nicer stretches of Bonita Beach Road east of 75. We dug a lake in the back to act as a buffer, along with a 10-foot fence with Hunters Ridge. Our master traffic impact statement at full build-out of the park, which we'll never get to as far as the allowable square footage, but even if we somehow got there, it would be concurrent and would meet all necessary traffic restrictions and would not require any alterations on Bonita Beach Road. The interconnectivity and infrastructure is already in place. We have reverse frontage roads in place for people to be able to go to Publix, no matter which community they live in on the south side of the road, without even having to get onto Bonita Beach Road. And again, this was all paid for already by the developer. Fourth, a while back, the park was approached by, I think it was Lee County, I don't recall if it was Lee County or the city, for an easement to construct a sidewalk on our property, which we granted without a fee, which is in existence now, and it runs the entire northern boundary of our property line, which is the south side of Bonita Beach Road. That sidewalk's in place. There's also crosswalks with safety signals at both Bonita Grand and Hunters Ridge. Fifth, and probably most important, and this is why I'm going to ask you all today to exempt this park from this moratorium in the event that it is even passed, is that it, in addition to all these restrictions that we have, is that the park's already more than 50% built out. We have multiple landowners with buildings. And because of the design review criteria and the way that we handcuff them in having to build beautiful buildings, they have an expectation that any future building in our development is going to look the same and that it's going to be built in kind to preserve their property values. They're going to be subject, any future building, Mr. McGarvey, will be subject to design review. He's going to be subject to setbacks. He's going to be subject to density. He's going to be subject to lot and perimeter requirements. He's going to have to put in streetlights. He's going to have to shield his HVACs, etc. And this presumption from existing building owners is what I'm worried about, because if we change the way that the buildings are built or positioned in our park, it's going to open us up to lawsuit, because they had the expectation when they built that the covenants and deed restrictions of our park would be followed. This is the northeast corner of the park. That's Bonita Grand Drive on the bottom and Bonita Beach Road. You'll see here, this is the crosswalk at the lit intersection, and this is the beginning of the sidewalk that runs the entire property line. You'll also notice the extensive perimeter berm with mature trees. That's the sidewalk facing west at that corner. This is the Publix, and I brought this up to show the interconnectivity. This is a reverse frontage road in here. This is one here. To interconnect, these roads will be extended behind the CubeSmart and will be extended to Hunters Ridge to promote interconnectivity. This is a sidewalk into one of the businesses off of Bonita Beach Road. This shows the plantings with the architectural detail, the mature oaks, the sables, the up street lighting that dresses up the park. This is a view looking south at the same corner. It shows the sidewalk that runs the entire southern boundary. northern boundary. This is the northeast quadrant. This is Hunters Ridge Parkway here, or Boulevard. This is the beginning of the McGarvey development. This road will be connected down, as will this. The utilities, water, sewer, everything's in place. The road just has to be put in. And that's the road there that will be put in. This road's in as well, it just doesn't show it. So, in conclusion, we have a sidewalk and bike path already in place. There is a bus stop already in place. Route 150 has a bus stop at the Publix at Bonita Grand. The reverse frontage roads and multiple full median cuts result in interconnectivity in place. We have a vested master plan MPD zoning resolution with updated and current master traffic impact statement. The park is more than 50% built out. We have stringent design review criteria in place. And it's been proven, if you look at the buildings out there, they're very nice product. I currently have a contract in place with a proven local developer that's scheduled to close in the third quarter. And we are located at an I-75 interchange, which is well outside the focus areas and the catalysts of this vision plan. So I'm asking that the Burnwood Park of Commerce be exempted from this moratorium. This moratorium may not even go into effect. And if it doesn't go into effect, that's great, because we'll just proceed business as usual. But if it does go into effect, it's going to create another layer of approval, i.e. City Council, that we normally would not have to go through. And I believe that asking Mr. McGarvey to have to go through that approval process is going to result in more time and more money. And it's not fair, because the park that he's going to be locating his buildings and building in already meets the vision. So if you have any questions.
Questions from the board?
Thank you.
I always need clarity, I guess. I'm trying to understand exactly what you said. The park meets the vision.
Yep.
So what exactly are you worried about?
I'm worried about time, because this contract is scheduled to close in the third quarter of this year.
So-
And I can't have the clock that's already been started and the dollars that have already been spent on
But if
engineering.
the moratorium says that if you meet the vision, you can continue.
But you have to go to City Council.
Okay, so there's
I
two ways
guess
to
I'm-
get it. There's to have more certainty, they would go to City Council, because they are doing a lot. Now, where they have issues, would be mostly building placement, I think, because I think you meet pretty much all the other
That's what I was going to
qualifications.
ask. Is it the placement like closer or further away
And my
from the-
argument is
Right,
the
and they
building
want
placement,
continuity.
and the
Yours
building
is
placement
further
we're going to have an
back.
issue with, because we have existing lot owners
That's what I'm getting at. So you're
with
building.
setbacks that are going to be, and we told these lot owners, this is how these buildings are going to be built. It's almost like if we were living in a residential development and 50% of the homes were built a certain way. And then all of a sudden they say, you got to build them this way. Well, what's that going to do to the property values of those existing lot owners?
Okay, I hear you. So I think what we're saying is we're putting buildings, the vision is putting buildings closer to the road.
Correct.
With the parking, et cetera, in the back. And yours is already toward the back.
No,
the
it's
buildings.
actually parking on all four sides. We don't have
Okay,
massive.
parking
The only
on-
one that has the
okay,
massive
okay.
parking lot is the Publix.
My
but-
other question is, don't we have other developments along that road that already that are done, that already don't meet the vision?
Correct, but they
Yeah.
already have all their COs. They're coming in
Right.
for additional applications for the new development portion. So this is not going to affect, Publix is going to be Publix. I don't expect anything to change in that shopping
Yeah,
strip.
that's what I'm trying to get
Right.
at, is how
So-
much effect it's going to actually
And-
feel.
and-
So
and-
pretend
I'll-
that shopping strip, that portion of Burnwood is not changing. The portion that would be changing would be the portion that has not been built yet, in front of Hunter's Ridge, on Hunter's Boulevard, Hunter's Ridge Court.
And is that
There's
the
one lot or two,
northeast
yes.
quadrant he was, got,
Well,
No.
southwest quadrant,
Southeast.
to make this
Southeast?
very simple,
right?
for the most part, we
Southeast.
agree with what he has to say. We, in terms of his concern about sales contracts and his internal development review standards, I would take those out of the argument and place those aside, simply because those are not A sales contract means nothing to me because I don't know, what you understand to be a contract or an agreement may not be the same for everybody. The second thing is the city does not involve itself in deed restrictions or internal review, whether it be architectural review or other sort of uses. However, the point that was made that most of this project is built, the fact that this project checks most of the boxes of that vision, and the fact that the portion that's not to be built mainly involves southern property or property that is not adjacent to Bonita Beach Road, he does make a point. I did have a conversation with Mr. Maurer a couple of days ago, and we discussed this fact. I told him that this was coming to your hearing today. I said, you may wish to show up and present your case. I didn't know if it was going to be something that you considered to be premature, if it was something you wanted to also make a separate recommendation to City Council that this be a project that you would recommend be exempt or not. That's entirely up to you. But the idea of presenting this to council for their review as to whether it should be included or not is something that we think should happen. Yes, sir.
This development order was issued before we became a city.
Portions of it were, yes, sir.
Okay,
Because remember we talked about the phases of
but
development
they're
order.
totally in compliance with everything at that time.
Yes, sir.
So that technically, if this hadn't come along, they could proceed along and everything would be exactly according to their original development order.
Well, there's been a
Well-
lot of administrative amendments as well as some
There-
amendments to
the
this,
original
too.
zoning for this had a lot of narrative controls, did not have a lot of visual or plan
But it was
approvals.
approved by somebody.
That's exactly right.
And so it was an approved development.
But
When they were approved development in place when we became a city.
Correct.
So when we became a city, we inherited,
That's
Essentially,
correct.
yes. Yes.
like we did everybody else. So the point that I'm having a little difficulty with is why then does it become an issue now if it was legal when we took it in? Why would it somehow have an issue now?
Because remember when I said that a lot of their controls and approvals are based upon narrative descriptions
But
and
that's
development
your
standards?
opinion, because somebody
There was not a building
Somebody
shown
in
on the
Lee
site.
County approved this in 1999, so it was all legal and approved before you
Well,
and I became,
Actually, it's
on the
not my
scene.
opinion. There's not a building shown on those lots.
okay?
So without that being shown, it's not like there is a building approved in a particular location, and now we're saying, no, that building needs to be somewhere else.
And
But the point that does need to be made is you do have buildings that are built, and you do have a development pattern that is in place.
And very nice too.
Right.
I can't say I have a problem with that, but when Mr. Maurer made the argument, if you allowed us to develop those buildings and those sites to previous standards, and now you want these to be built to a different standard, it's not going to look uniform. It's not going to have the same appearance. And I think that is a valid point.
Well, okay, we go back to, even though the plan may not be to our liking now, but it was approved by somebody in Lee County, and it was all legal. When we became a city, we got an approved development order out there that we accepted. So if we accepted it when we became a city, I don't understand why we're not accepting it now.
Two things. One, I don't have a problem with the plan, so it's not like I take issue with what they have approval for. And two, I don't necessarily object to the argument that's being made that this property should be exempt, or at least those properties along Bonita Beach Road especially, because I believe maintaining the existing development pattern provides more for the aesthetic than having them change course mid-development.
Yeah, I hear you too. It's really more incorporating with the whole design that's already there by staying with the same
Correct.
design than changing it. So you have one little area on the road, it's already changed, and you put another one, it still has, it's
And
still
what-
going to be the same.
Correct, and what makes it easy to go along with that is the fact that they do have the pedestrian access, they do have the bus stop, they do have pieces of this vision in place. If they had completely disregarded that or had gone in a different direction, it would be much more difficult to say, yes, what you have is consistent with where we want to go. However, they are more than 50% built along Bonita Beach Road, and a lot of the development patterns that they had approved and have implemented are consistent with the Bonita Beach Road vision.
As I recall, when this came about, I believe they added the sidewalk in after
Correct.
some years later, and at their expense and so forth. So I look at it and I think this is the kind of development that we would like to have, and I have difficulty putting stones in their path right now. I think that this is something that we inherited that was legal when we got it, and I don't see that it's any different now.
Well, I would suggest, my humble opinion, that if the rest of the board feels the same as you would first of all make a motion as to the moratorium, and then if you choose, make a separate motion as to the exclusion of this project.
A
Let me
recommendation
say
to council,
something.
because that would be council actually do the
Yes.
exclusion. not-
I have, after this piece that he's talking about that hasn't been built, what else out there is coming that wants to be built in this non-vision style that you know
I have
about?
several discussions with people that want to develop along Bonita Beach Road. At this point, I can state that I feel that one of them is consistent, has been working with us to implement the vision. Another is too early in the process to state whether it is or it is not.
Okay, but they all don't have any development orders approved yet.
Correct.
So
One of them does.
pretty
one of
much
them doesn't.
if we were to say, okay for this, we wouldn't have anybody else coming, if, I'm
I'm not
assuming.
going to say that simply because it goes back to what I said with disregarding what you consider a deal or a contract, because someone can state I had this vision in my mind,
Yeah.
but the vision doesn't mean anything until I have an application. And at this point in time, the people I've talked to are either too early in the process to make a determination, or those that are far enough along in the process appear to be working with the vision. So to my knowledge at this point, I don't know of anybody that is inconsistent.
Well, Mr. Mauer's project is not a vision. It's a reality that's been there and very good for out there. I thought years ago when it was started, it was way out in the country, but now it's going to be downtown one of these days. The point of the whole thing is that I feel that these were the things that when we became a city, they were important to us to have those kind of developments in place and so forth. And I just don't want to be put in a position where we're making obstacles to this.
Mr. Sims, you can keep beating me over the head with it, but I still agree with you.
In your
Yes,
Chairman,
sir.
I agree with Rex on this issue. I think this is, for lack of a better term, splitting hairs. And I think the board, that we should do whatever is necessary in our motion to allow this project to go ahead.
Let me say
I
something.
agree,
Let me
too.
add something, please. We're arguing points or debating points here with a lack of knowledge. The lack of knowledge, and Mr. Mauer points to this, comes out of this vision study. When you ask a building to be placed 12 feet off the road, you're changing the proposed plan here altogether. And I don't know if the board here has all of the information, the details of this plan that help us make a decision as to whether or not we're going in the right direction with this decision. Does everyone here
You
know
mean,
exactly
you're
what
talking
the
about
plan?
the vision?
The vision planning.
The vision
Do we know
planning,
the
yeah.
details of what they're asking developers to do to meet this vision that a person has for the city? The city council has bought into it, assuming that we here on this board and the zoning board understand all of the details of it. I know I don't. So what we're debating here is only one point that Mr. Mauer brought up, and that was moving a building to within 12 feet of the street. That's only one point. Do we know all of the other details?
That's what I was asking earlier, besides moving a building, what are the other things that's going to affect him?
Well, that goes back to
Yes.
my point of how does the designer reconcile what is existing and what has been approved against what his or her dream is? So,
Right. And can I now add what?
Sure.
There was a
Go ahead,
couple times
Audrey.
where I tried to assert, but I just want to talk a little history. And I know people will groan, but bear with me for a second. So this zoning was approved in 1995 when it was Lee County. A couple significant things to think about. One, Lee County at that time was endorsing what we called the bubble plans. So you can have the planners describe it better than probably I can, but a bubble plan is basically like a Venn diagram. It would just have a couple, it looks like bubbles, and that's where you would put pads, and everything was left to development community, similar to like a Houston kind of issue, where you almost have no zoning, but you allow the development to proceed consistent with whatever that bubble had. And so that was the philosophy at that time, and the council now, including the zoning board, who has asked the question where they think it's one of the members who's from another state felt that there might be like an unlawful delegation because he did not see the specificity, because our LDC, which generated from Lee County, doesn't have that specificity. We have very broad schedule of uses and able to do things. The other thing I wanted to point out, and very sensitive, I'm sure Mr. Colapietro and Mr. Sims is aware of it, I don't know if the rest of you, Bonita Springs was the hotbed of a comp plan issue called Rehard. Everybody remembers Mr. Rehard in that issue in the 90s? So there was a very strong, when City Incorporated, you know, philosophical, especially with the first Bonita Beach Road corridor, live and let live, because if you don't, and somebody had something and kind of even showed it to the government at one point without approvals, you could still try to argue equitable estoppel, and they prevailed, and the government ended up buying the property off of Imperial Shores, or Imperial Shores, you know, where there's a beautiful mangrove forest as a result of this. Because the county at the time said you could have 1 unit per 20 acres, and they wanted to have a subdivision, just like the Rehards, who did other developments, has subdivisions around. And Bonita Springs at that time, and this is prior to incorporation, it was almost a very hotbed of either you were the Rehards, dead right, government, you're wrong, or government's dead right, Rehards, you're wrong. Well, the law has since progressed, you know, and it is okay, but there comes a point where, you know, if you do have a vision and you're working on that vision that you have to implement, it doesn't mean, you know, everything is vested, because certain things you're not ever going to vest anyway. Building code, life safety issues. There is some issues that will probably be fine and some issues that won't, and we can ask council during the course of the process so that, you know, even if the moratorium doesn't go in effect, they still have those issues out there.
Let me ask you, I don't recall, did the team that was putting together this vision study, did they make a presentation to the LPA?
Mr. Lockley did. Yes, as well as Ms. Crespo? I believe so.
I don't remember it either.
That was the reason I asked the question about the details of the visioning study and what's being asked of us to do now. Unless you understand the vision study, how can you make a decision on the moratorium in earnest? If I don't know the details of it, unless Mr. Bauer had not made that point, I don't think anybody up here would understand exactly what this really means.
Correct. And so we don't go too far afield. This is not an issue that this board has to consider. This is an issue this board can consider. This is an issue that will be considered by the city council for their determination. What I think we're looking at is the question of what is the complete list of the vision versus what is in your existing zoning and what you plan to do with that going into the near future. And I have seen enough in place that goes through this, the standards of this vision, where they have implemented before the vision ever existed, that it does not necessarily offend me in terms of the request. If you don't feel like you have enough information to evaluate this, then I would not make a recommendation. The council will be looking at this. Council will be making a determination. And if this is something that this board says, well, we think the council should have the following pieces of information as part of their request, that's a different story. But I don't want you to feel that this is an item that's on your agenda that you have to debate until you come to consensus. If you have consensus is always good. If you can come to a recommendation that you all believe in, that's fantastic. In this particular case, because this is a sub-issue to the issue you've been tasked to evaluate, don't let this sidetrack you. We will be addressing this with City Council. This, just because you don't make a decision does not mean that we will not be discussing this with them. You've heard my opinion. We're not going to be going vastly far from that in either direction. The council will have the ultimate determination regardless of whether you make a recommendation or not. The main point is to actually debate your agenda item and to make a recommendation on that item.
John, thank you. I think that was helpful here, and I don't know how the rest of you feel.
Yeah, I wanted to say something
but
too.
just a moment. But I don't know whether or not I'm knowledgeable enough with the vision plan to say that, and what has been passed is going to impact this development or not. It may not at all. The requirements of the vision plan may be such that, yes, this property does look like it's going to meet everything we're looking for. Yeah, but I don't know.
I would say that the main topic of discussion is not the internal sidewalks. It's not going to be the multimodal access. It's not going to be the access to public transit.
Right.
It's going to be the setback line. I think that everything else in there, this applicant has either met or has met in their own way. Maybe not identically how the vision is laid out, but through their own development. Where I think that they're concerned, at least as far as I've been informed and understood, is that you have buildings that have been constructed to a certain setback line. And what I think is a valid concern is that they believe that the city may be asking them to change that setback line so they're building buildings closer to the road. And in terms of implementing the vision, that needs to be done. In this particular case, you have two parcels. Doesn't necessarily mean they would be two buildings, but two parcels that are vacant. And if those two parcels are built at a different setback line than the remainder of that existing development, they have concerns on how that will function and how that will be able to be sold. I'm not going to tell you that what the impact on a sale or lease contract is, but I can tell you that from an aesthetic standpoint, maybe this isn't the best implementation. The other standards that are included in there, I think generally are met, and we can go through point by point, maybe at the city council level. I'm not really prepared to do that today in terms of slides and examples, but just so this board knows, I understand your concerns with this, but this is not an issue that goes away. Mr. Mauer will be at the city council meeting. We'll be bringing this up, and this will be an item that they will address one way or another.
Yeah, thanks, John. You know, the concern here, though, and I think Mr. Merrill was talking about this, is that time is money. And every time you have to go to the council or you have to get on the agenda to be on the council, it's time. Being in the construction business, I know that that is paramount. How you borrow money, when you borrow money, when you close a deal, when you don't close a deal. All these meetings are fine, and they do present a lot of great ideas. But if you look at the other side of the coin and say, well, what are we doing for this developer here? He meets most of the criteria, but yet there's some in the new criteria that, if passed, could pose a real, not just a siting problem, but it's a financial problem, and it changes the character of the entire development.
Now, if I may, that's not a moratorium issue, that's a Bonita Beach Road vision issue, which
Right.
incidentally you did review November 10th. And I remember the review because I remember LPA member Gallagher and LPA member Jacobson very strongly on the issue related, I do, on as far as gated communities and subgates, when you have smaller gated pockets. And, you know, what's now the gated community was, you know, to us an open community because only a portion was gated. So I remember that conversation during that course of time. But that's related to the Bonita Beach Road vision and how council as well as community development determine what the actual vision is. And it's not a moratorium question. The moratorium only gets them past step one, you know, whether they have a stopple or something else. But they would always have, if they don't have a permit on the remainder for an actual building pad, design standards would still come into effect. Now, they have greater design standards than other developments, so most likely our issues would be probably nominal compared to the internal issues they have.
Now, Mr. Maurer mentioned that the impact for him and the developer is that it would involve resubmitting or getting on the council's agenda in the future here. And there's an overlap with the closing of the deal or this thing going through that is going to be impacted.
I understand that, and that's one of the reasons why item H on page 4 was drafted. So I cannot envision all the different legal claims that somebody's going to argue. They may argue latches, the doctrine of latches. They may argue equitable estoppel, whatever different provision. What they're required to do, if they have standing, property owner, prospective property owner, they can at any time during the moratorium, they don't have to be here today, they can do so anytime during the process, send me a letter, and I have 15 days from receipt of that letter for the council's next regularly scheduled. I do need some time to review it because it's not fair to me or Special Land Use Council if you don't let us evaluate. We just want us to slap it on for council's consideration because this is very fact-intensive as applied by the law. The other ones, which I call the play nice, you know, if they meet the requirements and staff agrees they meet the requirements, they're going to go and continue to public hearing.
But this, again, pushes this thing forward to a forward date. It's not here yet. And whether or not that coincides with Mr. Barrower's request, I don't know.
Well, and I see his request as two prongs. The first prong is the moratorium, which may or may not materialize depending on whether there's objection. If there's no objection, there's no moratorium. But there are some protections in the moratorium to address private property rights because we are sensitive to that issue. The second prong is the Bonita Beach Road vision, which is not before you today. Now, you did review it. You did find it consistent with the comp plan. We did transmit it after your evaluation and after council, was it February 2 or February 1? Whatever the city council meeting was, the first one in February. It then went to DEO. We received it back and processed it to the final public hearing. That particular ordinance, you know, will be subject to interpretation like anything else in the comp plan. You know, because I can have a sentence in the comp plan and Ms. Genson and I could violently disagree on that particular sentence as to how to apply it. I mean, then that's not uncommon. I mean,
And then just to follow up, at council's meeting next Wednesday, Alexis Crespo from Waldrop Engineering will be doing a presentation to City Council to prepare a scope on how to start implementing the Bonita Beach Road visioning amendments. So that will be before council, and I imagine that this issue will come up, and staff will be given direction on how to address things of this nature.
Mr. Chairman? I'm going to agree with both Rex and Henry on this. I think that's you know, you look at what they've done and look at their past records, and that includes Mr. McGarvey, because he's the one that's responsible
Right.
for Riverview Corporate Center, which you don't get much better looking than that. So I think that what they've done and what they plan is
Okay.
more than
Let me ask, are there any other public comments at this time? Okay, please step up, Mike.
Actually, what we were discussing was what's going to have to happen is determine whether this property is exempt or not. The council is going to want Tool Design's opinion. And we can send the current plans that they have to Tool Design and then present those to the council. So that way they will have his comments and be able to evaluate those. And that way the lack of information that Mr. Vincent had referred to won't exist at that level.
Okay, good, thank you, John.
Good morning, John McGuire.
Morning.
Thank you for your comment for Riverview. I think you're making a major disaster move with the reverse frontage properties. Okay, we were one of the first ones that did Estero Park Commons up on Corkscrew Road. That project is one where we wanted to put the back of the buildings up against the road, all the parking internally. What happens with that kind of building, two developers, they didn't fail, but just got killed but we didn't fail. The other one did go bankrupt and closed the doors. The problem is me and Joe D. Jameson did those 2 projects up there on Corkscrew at those locations. Great location, great accessibility, but they never took off. And the reason why they never took off was a result of the buildings being right up on the road. Then the contractor has no other choice but put the meters, utilities, and all that ugly stuff along the road. Sure, you can put bushes in front of it, they get kills it and they cut them out. The problem is nobody sees that the buildings are occupied and who's inside. Then you wind up with ugly signage all over the road. Tell me that looks any good. Go up there. It's disaster. You go along the road, there's no streetlights in there, right? I'm in the darkest place in the world. When you come out to that intersection, it's tough. But the way the plan for the Mowers and what we're doing at Burnwood is a perfect plan. Do me a favor, go look at Gateway. Gateway, I built 4 million square feet of space. 3 developers failed before me. I succeeded. Now, the reason why we succeeded, we did all good planning, things what you're asking for. We include that standard. We never had a question with it and where we're going. Number 2, I like grand landscaping. I like buildings that look good. People like to be proud and go look at them. Look at Riverview. I'm very proud of Riverview. I'm very proud of Gateway. You know, at the end of the dance, if you look at the Gardner buildings up in Gateway, we brought customers into the market because we had the vision to get to that next level. So I think what you're playing with this reverse frontage should be addressed clearly. We'll definitely show you data where 35% of the people went bankrupt because nobody sees them in it. So what are we looking at? Or are we looking at the problem we don't want to see parking lots? We can landscape them. We can make them look pretty. That's just the normal way of doing business. But the problem I have with it is when you have a master plan development like this is, and it's perfect. Everything they're asking for is not a problem. We've met with your staff, and we gave them the vision of where all the buildings are going to be. Today, we can introduce that to you people so you at least see it. We met with staff, and we understood what the elevations were changing. It was hard for me to swallow because I look at Gateway, and it's timeless. They're now 20 years old, and they look as good as the day they were put in. The problem, what you're doing, you're adding all this punching and offsets and that stuff, that kills the developer. Kills the developer because he doesn't have flexibility in this open box space. You're making me jog walls 20 feet. You're making me move buildings back and forth. Who's seeing me behind a cube storage space? Nobody. Just my own self. So we're paying approximately 20% more for that building to be built. Now you say, okay, can we afford it? That's the next problem. Now, if you're going to put me on a delay of another year, because what's going to happen, there's going to be litigation. We're just dreaming if you don't think you're going to get litigation. Montgomery's out there ready to attack. You know what I mean? She's already contacting me. I don't think it's going to be fun. You know what I mean? And putting it on a moratorium, I think you should exempt this project because it's done. Because I think you should look at our project, make sure that I comply with the new plan, which I think we are. Am I correct, John? Are we close? Well, I showed you the other ones, and I showed you the site plan. So I don't have a problem carrying that same theme that we're doing on the first building through all the buildings. At the same time, I think you got to look at it and say, there's a timing. And what's going to happen is the more people do not get pushed into a good example. If you look at the industrial park over at Railhead, that's the closest industrial park we have. That's more density in town. By me keeping it out on the interstate, on the highway system and the roads, makes a lot of sense. Every supplier would rather come there because they can go to Fort Myers, they can go to Naples. And I think you're not going through downtown Bonita. And I think that's a big plus. So I think by what you're trying to do is going to hurt long-term development. The other concern I have is, and it's one that I've had talk with John, was I like my buildings to look good in the front, and then we need more parking. Because what happens is parking is a big thing. You see me do it at Riverview, you see me do it at Gateway. I put, instead of it's 1 per 1,000 square feet of warehouse, I put in almost 3. Because I know people are going to have more people, more density, more later. It's easier to do it first in the beginning, count it as cost, and put it to bed. You then can do more different kind of operations. If it's more of a pharmaceutical lab or something else moves in, you're already covered. You don't have to come back and ask for variances and say what I have to do. I'd rather do it up front. So that's why you see in my master plan, I show the parking. The market out there is going to change, yes. But the problem is we're on a cycle. We're just coming out of the bottom of the trough. We're just coming out of it, and now it's time to run. We got a 2.5-year window before it goes down again. Let's be realistic. It's going to do the bubble turn. We're here on the cycle. Here's where we're coming up to. If you delay us a year and a half, we're going to say goodbye to the project. If you ask me to reverse the project on this one with reverse frontage, I'm probably going to walk because I bled the first one. I don't want to bleed the next one. My mother made me smarter to that. You know what I mean? So I'm saying just go look at those reverse frontages. They're great for people's visions from design engineers, but it's not practical to the market. And that's what's happened. And that's critical. I can send you all the pictures of Gateway. I can send you all the pictures of Estero Park Commons. 35% failure is not a good number. Everybody loses. Nobody knows who's inside those things. That's the bad part. Okay? Now let's talk about the rest of the site. What I'm asking for is industrial, because I think we have 2 buildings that we're thinking being industrial. And I gave plans for them, elevations, and we're just coming in, we're just waiting for our civil engineers to finish up their site plan and their finalization. Everything's done on the elevations. We submitted 3 sets of drawings in, we came to a couple meetings, we compromised, and a new plan is out to you, and I think we're all on the same page. I think we're there. I think from my standpoint, I think we're there. Number 2 is, I have one concern. Between the back of my buildings and Hunter's Ridge is 450 feet away, okay? Like Mauer said today, he had advanced planning, they put that berm in first. So first of all, you have a road that's 450 feet away to the nearest house. You have a lake behind it. You have a fence, a berm that's built almost 3 foot tall, plus a 10-foot fence. And they've landscaped the berm. There's 3 spots that needs to be enhanced. Them I'm willing to do, to make that those people never see us. Now, everybody gets nervous when they see an industrial park. But you got to remember, the industrial park is the nicest neighbor you could have. One, it's very quiet. Trucks come in and come out, not the end of the world. There's no outside storage. Number 2, at 6 o'clock at night, we turn the lights off in the back of the buildings. We just leave walking lights to keep us through at that area. So in turn, we're a very nice neighbor to our customers. But at 450 feet, that's 1.5 football fields away. Think about that. How is somebody going to see that through a 30-foot tree, through the vegetation, just because they don't want it? I don't think that makes good planning. You know what I mean? I don't see where I'm hurting them. I came back to them and said, okay, you're worried about the lights. Let me, instead of just everybody puts wall packs on the back of the buildings, I'm going to spend $5,000 a pole. I'm going to put poles on the backside and shoot it towards the building. So it's subtle, not eat at Joe's. I don't want to be eat at Joe's. Okay? The last item I'll get off my high box will be, what are we doing with the retail? The retail's in trouble. You can look at Publix, everybody's getting better. But look at all the stores that failed in there. You know what's wrong with it? Not enough mass. If I bought that parcel on the other side to work with that developer and myself to come up with a better way for a shopping center to succeed. And that's what we need in Bonita. That's where my vision is. If you put this thing and don't give exemptions for what's being out there and stays existing, I think I want to pull my offer off on the buy property. Because it's just, I'd rather not go through the aggravation and dump money into a hole and have trouble later on, because you're making a monster. That's all. Any
Thank
questions
you.
for me?
Thank you.
Good.
Any other comments?
John McGarvey is a man who needs no introduction. I, on the other hand, am Stan Stouter, and I am here as a property owner of 27971 Oakland Drive, which apparently, it's a little illegible on the exhibit, is impacted by this moratorium. I'd like to share some brief comments with you. First of all, I'm on the LPA in Lee County, so I share your mission and your service. Thank you for that. I believe that putting a moratorium on an 11-mile corridor is like going to the kitchen for a drink of water and flooding the kitchen. I believe it's an overreach, and I concur with Mr. Mauer's conclusion that perhaps the moratorium, if you do want to use such a draconian measure, should be limited to those intersections which are most highly impacted, being US 41 and Old 41. Audrey had used the metaphor of the shot clock, and with my wife out of town, I've done nothing but watch NBA games at night. And I have noticed that out of all of those possessions, less than 5% of those possessions end up with a shot clock violation. So let's not stop the whole game to preserve a 5% violation. I have the indistinct dishonor of having beat the impact fees in 2007, and I have office buildings that we sat empty with for a long time. It would be foolhardy for a developer to try to push forward an economically unfeasible project in an attempt to beat the shot clock on this moratorium. One up here was asking if there was a financial damage. Let me address that point. My property was just had its master concept plan extended and the uses embellished in December of 2016. It was about 9 months and $40,000. I agreed to 21 different stipulations. One of those stipulations, which was the hardest for me to suck down, was that I was given a 5-year window on a specific use, open storage and staging. That window got shrunk to 3 years if I sell the property to someone else. The highest and best use for my property today, given the surrounding conditions of migrant encampments, is vehicle staging and storage. If you were to invoke a moratorium, even though I may comply with the visioning study, which I support, my window got further shrunk. My 5 years, my 3 years got diminished by the additional time I would be saddled with to demonstrate that my project was in compliance. I am not so naive as to think that you will postpone my expenses, that the city of Bonita Springs will still want my taxes, they'll still want me to cut my grass and fix my fences. And so unless I can get an extension on these provisions that I agreed to, not knowing that this was going to be a possible delay, or those expenses can be abated, it burdens me. There's a further financial burden. You had mentioned financing. How do I go to my lender and I go borrow money because one of the stipulations that I was allowed to agree to was to extend Oakland Drive at my sole expense for over 250 feet. I can't just do that out of earnings. How do I go to a lender and say I've got a moratorium, and when you say the word moratorium, lenders blink and back up, and convince them that I'm going to be able to get through this study? Second, financial damage. I have a prospective tenant. Said tenant has a timeline for me to preserve him as an income stream. I got to get him in a certain amount of time. I can do that if I have a clear path and no uncertainty. But here again, as recently as yesterday, the word moratorium comes up, and now that tenant's back in water. Not sure if I can even deliver the product. So there is a financial hit for that. I am here in support of the overall visioning. As the LPA, your job is to find or not find if this proposal is compliant with the future land use map of the city of Bonita Springs. And I am not here to say that it is or it isn't, but I am here to say and to agree with Mr. Mowers and Mr. McGarvey that perhaps this drink of water should be limited to US 41 and Old 41, and the entire corridor should not be flooded, or it should be deferred until there can be a better finding as to its complicity with the city of Bonita Springs future land use map. There's a damage that's being inflicted upon us as property owners, and it's tangible and it's measurable, and it's making my ability to fulfill my civic responsibilities per my CPD very, very untenable. So please consider it carefully. Thank you very much.
Thank you very much.
Could I ask him a question?
Yes.
Mr. Stouter, I'm looking at zoning ordinance 1607, which of course is your ordinance, and there is a condition that at time of local development order, the applicant will work with staff to include additional conditions related to Bonita Beach Road visioning to the greatest extent feasibly possible to incorporate into the development order. So wouldn't you already be exempt by virtue of that condition because you already have that requirement?
Well, let me ask you, Audrey, would I be exempt from this moratorium if it was passed?
Well, there's already a condition in there that already has a requirement for you to work with us for that purpose. So I would say it's not applicable to your property.
Then I will speak on behalf of the other 11 miles of property owners who are going to get nicked if this thing goes through. And thank you for publicly making that opinion.
I'm just looking at your zoning ordinance, so I mean, that would be the logical conclusion. Right, but the council, and that's why I want to take a quick look here. The council that is currently on board, if I can never get to the end of your zoning,
I know
It's
the
same
feeling.
council who put that condition in.
And my intent is to be complicit with the Bonita Beach Road visioning study. I'm a corporate citizen. I'm trying to take what are dilapidated encampments around me and turn them into more financially viable and economically better opportunities. But I'm an ant lifting a boulder. This is difficult, and a moratorium, though I would do whatever I could to be compliant with that for the benefit of the citizens of Bonita Springs, it's just another layer and it's another level of uncertainty, and we all know that a confused mind always says no. So when I have a tenant and they're a national entity, and I've got to deliver this through a limited development order process, and I read that, and I'm aware of 4G as an exception, that creates a great deal of uncertainty, and it's a very competitive market, and it's a very fluid market, and a moratorium would be putting in a static fixed point in a market that's very fluid. And I concur with John's conclusions that, as we all know, this stuff works in cycles. And there's a demand now for what John wants to build. There's a demand for what I have. And if we elongate this through more, and I know that they've approved it, but for me it's unknown. It's nebulous to me. It makes us further into that cycle. And, we've all been kicked in the shins through 7 to 12. And my mom was like his. I'm smart enough to not want to do that again. So I will comply with the zoning ordinance that I've agreed to, and hopefully that will exempt me from this moratorium.
Right, and I just want to point out for timing purposes for the LPA, this zoning condition was added to the zoning ordinance. At that time, the LPA had already reviewed the Bonita Beach Road vision. And it was going to council for their February hearing because it takes a while for it to get set up. So this was decided by council after your November on December 19th, 2016.
Okay, thank you very much.
Thank
you. At this time, I'd like to call for a motion.
Mr. Chairman, I have a little problem with this. We've been down this road before about moratoriums, and I believe in the previous ones we have established that there is not a direct link between the comp plan and moratorium. So I would make a motion that there is, that goes something like this, that there's no direct connection between the comp plan and this ordinance, but this, we agree that the city has the authority to impose a moratorium. That would be one, and two, that I would exempt the Mar property.
Second.
Let's take a vote, please. Or any comments? Okay.
I just have one. I would like to defer to Mr. Dahmer, who, in my opinion, is an expert in this area, and I would just ask for his guidance because, like you stated, Mr. Chairman, we don't have a clear understanding. You seem to be in the know, so I would defer to you and ask you for guidance, and because I respect your opinion.
Thank you. My best guidance would be for Mr. Sims to split his motion to one, simply state there is not a connection between the moratorium and the comp plan, and the second would be an exemption language. And I'm not really sure if this board really wants to even to take a stand, only because there seems to be a lot more confusion than there is answers. And what I will state is that while I have said, and while several people have made statements that there's a lot of consistency between the plans, especially in Burnwood, and those of the vision statement, any project that's going forward is generally going to be reviewed by the city's consultant that created the vision, and his recommendations will probably be those that the council listens to as to whether it is or should not be exempt. So while I can make statements, other staff members can make statements, we are not the creators of that vision, and the creator of that vision will be making recommendations.
Well,
Yes,
John, let's establish, I believe the first thing, our instructions here are to give an opinion as to the continuity with this ordinance with the comp plan, and really, as we have discussed in the past on a couple other occasions, there is no relationship between the comp plan and a moratorium, although we all have agreed in the times we've used it in the past that the city has the authority to do that. But this group does not have the authority to say, yeah, it complies with the comp plan, because legally there is nothing.
In the previous cases, I think that that statement has been valid. In this particular case, I'm not so sure that you can take it from that previous experience and place it into this experience. And the reason being,
But
city is-
John,
No, no,
I
I'm-
hate to interrupt you, but when you go to item 3 of our instructions right here, it says for consistency with the comp plan.
And that's straight
being
out of
there isn't a
statute.
consistency, I have difficulty.
I understand. And the reason why I think that this one is a little bit different, and you can disagree with my line of thinking, but the city has adopted a vision. And the moratorium is, if that vision is challenged, that we determine whether it is a valid challenge or an invalid challenge before we process applications that are inconsistent with that vision. So in this particular case, the moratorium is to protect an adopted vision. In other moratoriums, there was not an ordinance that was immediately passed and an attempt to protect either that statement or that policy decision. It was previously policy interpretations that they were looking to distinguish. This one, a vision has just been presented, an RFP went out, a consultant prepared a vision, that vision was adopted. This moratorium is presented to you because that adoption might be challenged.
I understand that.
And
But
that's why I
let's-
think there's a distinction. Now, you can disagree and simply state there is no.
I'm not disagreeing. I see what you're saying. But I'm saying here we have an opportunity right now to make changes in the comp plan. And here is an issue that's come up. Originally, it just came up once over the homeless shelter, but it's apparently going to come up more and more now. Then there should be something in this book that has a guidance for the city to prepare a moratorium, because that's what you're asking us to do here.
May
All
I,
right, let
may,
me go back a
may I
little
ask
bit.
Audrey to comment on that?
Yes, thank you. First of all, case law is abundant that moratoriums must be processed the same as land development regulations, which is what you normally get for review for consistency, which is why we're here today to the local planning agency. As to consistency with the comprehensive plan, we have done moratoriums where we've had generally, we have done moratoriums in the past where we need to get a land development regulation in place for purposes of, a potential issue. I'll give social services as an example. And that was one where I think I put in the word social services and I found one reference to Goodwheels in the comp plan. It was devoid of any discussion of it. So that would make it sense in that particular moratorium why you might say, well, we really don't have opinion as to whether it's consistent or not with the comp plan, because the comp plan doesn't address this. In this particular circumstance, the comp plan will be addressing it because that's the amendment that went to council, went to the local planning agency in November. So there has been that review, and assuming this goes forward because of a challenge, but for that challenge, that the language of the Bonita Beach Road vision, those maps that are attached, would be in the comp plan. And having properties follow through with what the comp plan's goals, objectives, and policies makes sense for consistency with the comp plan, because that was the whole purpose of this particular moratorium. Now, as I pointed out, the moratorium only goes in place if there is a challenge to a comp plan amendments that this board has approved and found consistent with the comp plan. Now, I understand memories from November seem to be not as sharp as I seem to remember. I can remember particular discussions during it. I can remember Dr. Banyan being here. I don't know, Rex, if you were here or not. I certainly remember Carolyn, and I think you were on the board at this point. I'm not totally sure. If Jeff was,
I don't
Rex
think
No,
has-
so.
his
Rex has
probably
always
gonna be
been
after.
here.
so his appointment's after, so he doesn't know it. I don't know what you know or what you don't know, but it has gone through the process. So the moratorium is to protect the comprehensive plan. To ergo, try to say, we don't see a consistency issue, but we don't have a problem with the comp plan, really kind of shirks your duties in this particular case, because the whole purpose of this particular moratorium is to protect the comp plan.
So the two-pronged point here today is, one, you can approve of the moratorium, but you may not approve of exempting this property at this time.
Yeah.
Or you might approve it.
Well,
and
any
exempt it.
I have a
exemptions is
question
not
on that.
something of your, I mean, that's above my pay grade, that's above your pay grade,
Yeah.
above John's. We will take it to council, and any recommendation.
But we'd make a
course, we're gonna-
recommendation to either
right.
accept that or,
And that item, and I explained this to Mr. Maurer, that you may decide that or making a recommendation on an exemption is appropriate, you may decide it's not appropriate. So there have been no promises made that there would be a recommendation on that exemption status coming out of this meeting. I did state it was probably a good idea to begin the discussion of this property, but in this particular case, your only task that has been assigned is the moratorium. If you choose to look at a particular property and make a recommendation on that, that is your discretion, but it is not one of your agenda items.
And
But-
shouldn't we separate those two things totally?
That would be my
Make them
recommendation.
two different?
I made them in two different motions. so-
right.
Sorry, I thought that was
I
one.
was thinking it was one
I-
motion with this is A and this is B. That-
Let me say there, though, that what Mr. Merrill is talking about is that everything that he's been talking about here then falls into the hands of the authors of this plan. If you don't make a recommendation to exempt this out of the moratorium. So that's correct. That decision will fall on not us. It'll fall on the design team. That design team will then make a recommendation to the council as to why this property does or does not meet the vision plan. And one that was mentioned here is a big one, in the reversing of the parking in the buildings. That's huge.
I think we're both going to make recommendations, this council here and the design team, right? It's not just going to be us and it's done.
Nope.
It's going to go
Correct. This-
to them, too.
The council will be the ultimate arbitrator
Yes.
of any request.
So they will
and-
have both of our opinions.
And so, regardless of the action of this board, I plan to send, because there is an
Yes.
active, it hasn't been officially requested yet, but there's every intention that they want
Right.
to be exempt. So we would send their plan to Tool Design, request their comments, and when we receive those comments, hopefully we receive them
Yeah.
so that we can bring this to the next council meeting. But whenever we receive those will go to the council meeting for their review.
Okay.
As far
And
as I know, the only problem is the mirror imaging of the building and the parking. Is that correct?
Well, and I didn't want to get into that level of detail,
I
but
know.
I think that when we get into the body of this overlay in this vision, the other requirements that are in there should apply. When we start looking at interconnectivity and the sidewalks, and a lot of them are in place, but if we're going to make an exemption, the exemption should be limited, at least in my opinion, to the development standards, to keep them consistent with what's part of the existing development. But there are implications with that, and what exactly does that mean? There are a lot of details that I'd much rather have a plan that we can point to and state, this is, in our opinion, good, and this is, in our opinion, bad. So I've tried to steer clear of it and simply speak in generalities that they do have a lot of the boxes checked. Sidewalks are in place.
So does that mean that if we say we would grant this person an exemption, that you would continue to have parameters, A, B, C, D? These are the things that we have to kind of stay within, not necessarily the vision, because we're granting them an exception for that, but you would still have sort of a
What
a
I think,
ballpark
what I think we
thing
would
of-
see is whatever comes out of this board will come out of this board. Separate and distinct from that, we will have a review from Tool Design. And that review will basically be on whatever information that the developer provides to
Mhm.
them to review, and he will make his comments. Based on comments that I've seen, he tends to state, this is what I like, this is what I don't like. On that past experience, I would assume that there'd be a very similar situation here. There are things that he would like, and there are things that he would not like. And it's those things that he likes, going along with this, that he may consider consistent and work
Okay.
with that. But I do not know that, and I do not want to speak for him before he's had a chance to even look at the plan.
And when we give exemptions to one person, it's always an individual basis, that anybody else with any difference of opinion with a different development would come back individually, where we would look at that.
I would look at the decision or the recommendation that this board makes and the decision of city council to be based upon individual factors and local development patterns. Any additional development or developer that wishes to come in for an exemption would need to prove their case the same way
Okay.
that an original developer requested, and their argument would need to stand alone and should not be based upon the recent
Okay.
approvals.
And I
for
would
exemptions.
agree to that, but we had talked about having some criteria. So would there be a set of criteria to look at these exemptions, like how much of the development is finished, how long it's been going on, is the order still current, is this really a case of fairness, whatever the decision is, and what is the financial impact? Are
Miss-
those certain things that you would look at for exemptions?
I believe that if there are going to be criteria established, we should probably take that direction from the council, who would probably take their guidance from Tool Design.
Okay.
So establishing that criteria at this point, I think it's a valid question. I think it's a very good line of thinking, but I think we may be premature to establish that list
Okay.
at this level. because
I'm just asking,
no,
asking the questions.
I think it's a very good question, and I don't want to discourage it, but I think that we will all take our guidance from the final decision of council, which will probably take
Yeah.
their guidance from the consultant who
Okay.
created the vision.
And I have one other thought. I don't know how valid it is, and I don't even know if I can express it correctly, but when you're, Sam had an idea, we should know, the vision plan, and so it would help us make decisions. I'm thinking maybe on a case like this, it really doesn't matter as much what we know about the vision plan, in my mind, as I know I will have people who disagree. I'm thinking we need to look at fairness. And some of those criteria, I said we need to look at financial impact. We need to kind of, in general, look at what is it really going to do if he builds it the way he's always built it? Is that going to really mess things up? Well, in this case, maybe not, because the rest of the development, more than 50% of it is already built the way it is, and it's right in the same area. So, I don't know. Maybe I'm totally wrong.
Yeah,
but
let me answer your
do
question.
you
a little
understand
bit
what
here.
I'm saying, though, right?
I do, and it's.
And I'm not discounting the vision,
No,
It's
and what I'm looking at is what Special Land Use Council provided me for another moratorium in it's the city of Alachua, not the county of Alachua. And what they have is they drafted the administrative remedy a little bit differently than what we did, and some of the purposes are a little bit different. But his section number 2, and I'm going to read this out to you because I think it's what you're talking about. I'm not saying I'm putting it in exactly as is, but it is something I want to come here. People who can get administrative relief would have to have an application, like the letter I mentioned, that contains an allegation of a temporary regular taking to be evaluated pursuant to the criteria described in Rehard versus Lee County, like we talked about earlier, the 11th Circuit 1992 case, which that was not the final case. That was during while they were going through, which is A, whether the property will be denied substantially all beneficial use of the property. B, consideration of economic impact of the temporary moratorium. And C, the extent to which the temporary moratorium has interfered with the property owner's investment-backed expectation. The following is a non-exclusive list of factors, so it's non-exclusive. You don't want to try to be definitive to all because some things will apply, some things won't. List of the factors to be analyzed under these criteria. 1, the history of the property. 2, history of the development. 3, history of the property's future land use map classification. D, history of the property's zoning. E, any change in development when ownership changed. F, the present nature and extent of the property. G, the reasonable expectations of the property owner and the neighboring property owners. And H, any diminution of the property owner's investment-backed expectation. Then number 3 on this, a new section, the city manager or designee, John, shall make a determination within 30 days of receipt of the complete application whether to grant or deny, made by the city manager, which can then be appealed to the city council by filing a written request with the city manager within 10 days of the city manager's determination. Failure to file such an appeal shall constitute a waiver of the property owner's right to challenge the city manager's determination. So that's a more extensive than what I have in here. I did talk with Special Land Use Council last night, and they did want to make some changes, so my guess is this is going to be, we've already talked pretty hard too, is going to be some of the changes that are going in. And one of the things which is incidentally interesting, and he wrote this before we ever had these conversations, this is an older moratorium, is I think the statement I put in an email is this is Rehard country. This is where the Rehard case actually occurred. So we are very sensitive.
Well, that's a very broad list of criteria.
Well,
And
again,
I'm not
this is-
sure we want to be
Well,
that broad. In looking at this case and my thing, this guy has 50% of his property already complete, and he's had the order for a long time, and it's still current.
Mrs. Gallagher, you, like I told you before, you ask a very good question. And it's not that I don't see the argument that he has made, but one thing that I think has been abundantly clear with the city council is they require a full analysis of proposals. They don't want quick and dirty thoughts and then just be done with it. And that's why I've been a little hesitant.
Well, I think
because-
that's good.
And I don't wish to sound indecisive because we do like to have definitive recommendations. But this particular case, it was a very recent conversation that we've had on the impact of this particular ordinance on this particular property. And I'm not going to tell you that I've had enough time to even personally determine impacts. And while I'm sure I will be testifying to this and to the impacts of this ordinance on this particular property at the council level, it's also going to be a consultant that has not seen this plan whose comments are going to be included as well. So when we start looking at the conditions for, or the criteria, if we're going to set up for exemptions, I think that might be a good place to start, but this is the first time I've heard it, and I don't wish to go into a lot of detail or detail enough to make a recommendation on it at this point, simply because it is not going to be a core component of what is before you right now.
Thank you, John. I want to move on, and before we reinstate the motion here, let me say that Rex is right on target when he says that we're here to interpret the code. Okay, and I think we need to keep that in mind when we start asking so many specific questions about some of this stuff. Is that all you're to do is compare what's being proposed to the code. So with that, could you restate your?
I could,
My first one is, as there's no direct connection between the comp plan and this ordinance, we determine that the city has the authority to impose a moratorium.
I'll second that. You want to vote on that first?
I think we could, yes, just keep them totally separate.
Jeff Maturo,
Aye.
Henry Byrd,
Aye.
John Filipetro,
Aye.
Carolyn Gallagher,
Aye.
Rex Sims,
Aye.
Meg Jacobson, Chairman Vincent.
Aye. Now
my
for the
one.
second, yes.
All right. My second is that this, we would provide an exemption for the Mar property.
You recommend that we,
Yes,
Yeah,
I
read
don't know
what the
exactly
city
how to
council-
word that, but I would recommend an exemption for the Mar property.
Second.
Is it okay if I call it Burnwood? It's Burn.
Okay, let's take a vote on that.
Henry Byrd,
yes.
Jeff Maturo,
Aye.
Don Colapetro,
Aye.
Carolyn Gallagher,
Aye.
Rick Sims.
Aye.
Chairman Vincent.
Aye. Motion passes.
Thank
We
you,
go
gentlemen.
home.
And before we go on to the next item, won't we take a short 10-minute break?
Yeah.
Sure.